today's HIStalk webinar. The title of the webinar is The HIPAA Omnibus Rule, What You Should Know and Do as Enforcement Begins. It's supported by the Advisory Board Company. I'm Lori from HIStalk, and I will be moderating. Attendee phone lines have been muted to prevent background noise. You can use GoToWebinar's questions box in the console at any time to submit questions to our presenters. The presenters will answer your questions during the Q&A at the end. If we run out of time, the unanswered questions and responses will be sent to all attendees in our follow-up email. Today's webinar is being recorded, so you'll also receive a link to view it in that same email. We have two presenters from the Advisory Board Company today. First up will be Rebecca Fayed. Rebecca is Associate General Counsel and Privacy Officer for the Advisory Board Company. In this role, Rebecca advises on and is responsible for all health, regulatory, and data privacy matters. Following Rebecca will be Eric Banks. Eric has been the Information Security Advisor for the Advisory Board Company since July 2010, and he has over 17 years of combined experience in information security and IT leadership. With that, I'll turn it over to you, Rebecca.
Thanks, Lori. I thought an interesting way to start off today's presentation would be to disclose a little bit of protected health information of my own. Just wanted to give everyone a heads up that I'm fighting a little bit of laryngitis, but I've been on a no-talk ban for about 9 hours, so I'm hopeful. But if my voice sounds a little bit odd to you, it's not just you, it's me. And so I'm hopeful that we'll get through this with no problems, but please excuse that little bit of an inconvenience. So with that, we'll move forward. Based on today's webinar, what we're hoping that you'll take away from this conversation is the fact that you'll be able to recognize how the HIPAA Omnibus Rule allows us, the HIPAA Omnibus Rule most significantly changed pre-existing privacy and security obligations. It'll also help assess the privacy and security compliance programs and how you can actually integrate some of those best practices into your existing compliance programs. And then finally, we hope that you'll be able to prepare for and respond to any potential breaches, security incidents, investigations, or audits. And as my colleague Eric will allude to, it's really not a matter of if. You should be prepared for when you might be subject to an audit, an investigation, etc. So when I read this first slide, the Omnibus Rule, I feel like this slide should say something like, do you remember where you were the day that HHS released the much anticipated Omnibus Rule? I remember it being a cold, late January day, and I was driving home from work and driving to pick my children up, and I sat in breathless anticipation of going home to read that rule. So that gives you a little bit of insight into some of my personality issues. But I think the important piece to this is that it was several years that we were waiting for this Omnibus Rule. We're talking almost 4 years after the HITECH Act was issued that we finally got our hands on the final Omnibus Rule. And so I also feel like the slide should have a ticking clock on it, where we're looking at the date today, September 10th, and we look and we say the compliance date is September 23rd. And so it's really a matter of what should you know today, what should you be doing to prepare for it, and then again, not just September 23rd, that's the compliance date, but what should you be doing after that? Because September 23rd is, yes, technically a legal compliance date, but it's so much less than that, meaning that it's really about what are we going to do going forward to make sure that we are all protecting the privacy and security of health information. So generally speaking, what did the Omnibus Rule do? Technically speaking, it implemented the HITECH Act and certain GINA requirements. It then modified, by implementing these, modified privacy, security, breach notification, and enforcement rules under HIPAA. But practically speaking, it increases obligations for covered entities and business associates alike, increases liability, and certainly increases oversight and enforcement. And when I think about it, I feel like after so many years of us sitting through lack of enforcement, lack of oversight, etc., that it really in practice creates a whole new HIPAA world for covered entities, business associates, subcontractors. So just an overview of what we're going to talk about today with respect to the most significant changes under the Omnibus Rule. And we'll certainly go into each of these in more detail. But first, we're going to talk about breach notification obligations. And what's the big deal there? The big deal is that there's no more risk of harm. But as you'll hear me argue in just a few minutes, did anything really change in practice? Is it really as significant as everyone would lead you to believe? Business associates will talk about who are they, what must they do, what happens if they don't. And I think that's a very significant change under both HITech and the Omnibus rule. There were significant changes in that space. And then we'll talk about use and disclosure of PHI. And the Omnibus rule did two things. It certainly increased the limitations on the way covered entities and BAs can use and disclose PHI in some ways, but fortunately also expanded some of those abilities to use and disclose PHI. Then we'll move on to individual rights. So again, there were some individual rights provided, but what I would say is what most folks are talking about are the questions that have been left unanswered. And then finally, with respect to the changes, we're going to talk about increased oversight and enforcement. I alluded to it a minute ago saying before the HITech Act, before Omnibus, it really was lack of enforcement, little oversight. And what the Omnibus rule does is it's a game changer. It's a game changer for covered entities and business associates alike. So let's get right into the meat and potatoes of it. Breach requirements, so breach notification. And what we want to really let you know is that the basic rule remains unchanged, remains the same. And it's upon the discovery of a breach, capital B, because it's a defined term, of unsecured PHI, and that hasn't changed. Unsecured is something that's not encrypted nor destroyed. Covered entities and BAs have to make certain notifications with respect to that breach. So what's a breach, a capital B breach? It's really an unauthorized access, use, or disclosure of unsecured PHI, and here's the real bulk of it. In a manner not permitted by the privacy rule, that's bulk number one, and bulk number two is that comprises security or privacy of PHI. And again, it's subject to certain exceptions, and we're not going to go into those because those did not change, but it's really all about what compromises the security or privacy of PHI. In the old way, we'll call it the old way in quotes, under the interim final rule, it really was about whether there was a significant risk of financial, reputational, or other harm to the individuals whose PHI was disclosed. And if you followed this, this is probably one of the most exciting back and forth conversations in privacy and security history. But Congressman Waxman's committee weighed in publicly and challenged HHS's inclusion of the risk of harm threshold, saying that it was not in line with the HITech Act. It wasn't authorized. Congress specifically did not want a risk of harm. It didn't help that the FTC's breach notification rule, also issued under HITech, did not include the risk of harm. But HHS certainly stood by it for a number of years, saying that it was consistent with the HITech Act, and they stood behind it. But if we were sort of to look into our, and take a magnifying glass and think about it, and were any of us really surprised that the risk of harm was taken out of in the Omnibus rule? I personally think that the risk of harm was always at risk of being eliminated, really because you had a lot of push by Congress saying that it was not consistent. But what I would say is that in practice, despite the fact that the risk of harm was taken out, I do not think that the actual analysis that covered entities or business associates must undertake in response to an impermissible disclosure actually changes. I think it's very much the same. If I had to explain why I think it was taken out, there were really two schools of thought following the interim final rule. The school of thought that I always followed was that you had to prove that there was no risk of harm. And if you couldn't prove there was no risk of harm, then it was a breach. But there certainly was a smaller school that had the belief that it was about proving that there was harm. And if you couldn't prove harm, or there was no suggestion of harm, that there wasn't a breach. And so, this is my own personal opinion, but I really think that the elimination of the risk of harm was meant to say, yes, those of you who follow the school of thought of prove no harm, you're right, so to speak. And it eliminated that little gaping hole, but that hole that existed where folks could say, well, I can't prove harm, so there must be no breach. So under the new rule, under the Omnibus standard, there's a presumption, and that's probably one of the biggest changes, at least on the books, so to speak. There's really a presumption that if there's an impermissible acquisition, access, use, or disclosure, that it's a breach unless, and here's the key point, unless there's a low probability that the PHI has been compromised. So covered entities and business associates actually have to conduct a risk assessment and document that risk assessment, utilizing a 4-factor assessment to show whether there's a low probability that the PHI has been compromised. So those 4 factors are up here on the slide. So the first is really the nature and extent of PHI involved. So what you're really looking at there, what types of PHI are we talking about? Are we talking about social security numbers, names, diagnosis? Or are we talking about just a list of zip codes from where patients came? And so as you can see, you might come to a different analysis as to whether it's a breach if we're talking social security number versus a zip code. The second factor is unauthorized person who used the PHI or to whom the PHI was disclosed. For example, was the recipient just another covered entity? And if it was another covered entity, you may say in your analysis that a covered entity, the recipient, has an underlying obligation itself to already protect the data. So it's not as though the PHI has truly been compromised. Again, it's very fact specific, but these are the types of things you want to be considering when you're doing this assessment. The third is, has the PHI actually been acquired or viewed? So for example, can you prove that the recipient actually never saw the data? For example, could you do a forensic analysis if you get a laptop back and you can show that the PHI was never accessed? I mean, that's a fact you're going to take into account to determine whether it's been compromised. And then finally, you're going to look at the extent to which the risk to the PHI has been mitigated. So for example, if the covered entity in my earlier example was the recipient, did you immediately reach out to that covered entity and confirm that the covered entity has not used or disclosed the PHI, that they've deleted it, that they have not sent it on to someone else? Are you doing all of the things to make sure that you've mitigated any risk that the PHI has been compromised? And so as you can see, it's very fact specific. But when I read these four factors, I can assure you that these are the same four factors that I would have used when I was defending my clients before I got to the advisory board. I represented covered entities, business associates, et cetera, in private practice. These are the assessments that we were doing anyway. So this is really a four-factor documented risk assessment that is the same questions folks were asking when trying to determine whether there's a risk of harm. So when I say the risk of harm is gone, but are we surprised? What I'm saying is that in practice, very little has changed. So moving on to the next category of changes under the Omnibus rule, I skipped over one. Notification obligations remain the same. So I was talking about how very little has changed with respect to whether a breach has occurred, but the obligations remain the same. So if you come to the conclusion that yes, there has been a breach, covered entities have to notify the individuals affected. HHS needs to be notified at the same time if it's more than 500 individuals affected in total. If there's less than 500, it needs to be within 60 days of the end of the calendar year. And then I think finally, and what has probably been the most shocking to every time I tell someone this, in our training here at the advisory board is, if more than 500 individuals are affected in any given state, that prominent media outlets must be notified. And I think that I can probably visualize everyone on the phone shaking their head thinking that was probably the biggest blow to everybody, and that your reputation is really at stake if something like this happens. Business associates, they also have obligations, again, just like they did under the interim final rule, to notify covered entities without delay, but within 60 days. I think one of the most interesting pieces of this is that although there's a 60-day window for BAs to notify covered entities, it's a very highly negotiated term of business associate agreements. And really it's a matter of how quickly must the BA notify the covered entity. I know we at the advisory board, I don't think I could sleep for 60 days knowing that we had a breach if we had one. So I think the business associates should take away the fact that you want to let your covered entity clients know as soon as possible. I mean, no one wants to be sitting on information about a breach for 60 days. The quicker you respond to things, the better. Obviously with the right information you respond, but I always feel that the quicker you respond, the better. So moving on to business associates. Here's another instance where I'm going to tell you that I think there's a lot of hype, much ado about nothing. There's been a lot of talk about who's a business associate, and that the Omnibus rule, HITech and the Omnibus rule, they've really expanded that definition. And certainly the words have changed. I'll give you that. But I would say that it's really the same actors, and it really just confirmed what many of us already believed to be the case. There were certainly some holdouts, some industries that were saying they were not business associates when many of us argued that they probably fit within that definition. So if we look at the old definition, generally it's a third party, so it's not someone within the workforce, that provides certain services to a covered entity. And that's the first part, so you're providing certain services. And the second element is that involved the use or disclosure of PHI either by or to the third party. So that's pretty straightforward. So the new Omnibus rule definition is fairly close. But again, it's a third party that provides certain services to the covered entity where the third party creates, receives, maintains, or transmits PHI. I think one of the biggest ones here, one of the biggest changes, or one of the biggest clarifying words was the inclusion of maintains. I'm going to skip down to number 3 here because I know, people ask, what about cloud computing providers? And if you've attended any of the HIPAA conferences across the country, this is almost always included within some presentation. And the issue always becomes cloud computing providers and the issue of, are they just a conduit through which data flows? And I think HHS really tried to make clear within the definition that maintains loops in, if you will, and Eric's going to talk more about this, loops in those cloud computing providers as business associates. But what's very interesting is that HHS wanted to make it very clear that specific entities, taking into account the change in healthcare and the change of the types of entities that we have out there now, that excuse me, HIOs, e-prescribing gateways, other transmission services providers with routine access to PHI. So if you're just I'm going to use a real non-technical approach here, but if you're just the pipes, if you will, kind of like the mailman who delivers your mail. If you're the pipes that look like a mailman that you're just shooting data through, probably not a BA, but really need to do a close assessment of whether you maintain that data. PHR vendors that are engaged by covered entities, the distinction there is that PHR vendors who are not engaged by covered entities, those who are engaged solely by the patients, who market to patients, who have the patients open up the PHR through them, those PHR vendors are covered by the FTC breach notification rule. PHR vendors engaged by covered entities, if you look at the definition, are third parties providing services to the covered entity. They are business associates. So PHR vendors will, for the indefinite future in my book, I think, wear 2 hats, and it really depends on who are they answering to. And then finally, a subcontractor that creates, receives, maintains, or transmits PHI on behalf of business associate. So those are really the subcontractors of the business associates. They're BAs as well. And what this really does is it creates this chain, if you can think of a chain tying everybody together, back to the covered entity. And from a legal perspective, the important thing that they put in the Omnibus rule is that covered entities do not need a business associate agreement with each of those subcontractors down the chain. If you think of one unbroken chain, the contract flows down so that ultimately the subcontractor through each of the other subcontractors and BA is ultimately responsible to the covered entity, but there is no need for subcontractors and covered entities to enter into their own agreements. So we talked about who is and who is not a BA, but what's really the important part here? Business associates under the Omnibus rule have new obligations. And we already talked about the first one, so breach notification obligations. The biggest one, though, I think, is number 2. And Eric is going to talk in much more detail about this. But this is the, whoa, are you kidding me kind of moment for business associates, that they have to directly comply with the HIPAA security rule. Number 3, and this is probably one of the most confusing parts of the Omnibus rule, high-tech and Omnibus, is that, let me make it very clear, business associates do not need to comply with the privacy rule in its entirety. Again, it does not need to comply with the privacy rule in their entirety. They do with the security rule, but not the privacy rule. But what does that mean in practice? What they are required to comply with is the use and disclosure provisions of the privacy rule. So a business associate may only use or disclose PHI consistent with the privacy rule. It doesn't require the business associate to have all the administrative features of the administrative requirements of the privacy rule. It doesn't require it to necessarily provide all the individual rights. A lot of that is left to the BA agreement. But number 4, this in best practices, even if, for example, in the privacy rule, you as a business associate are not legally required to implement the administrative provisions of the privacy rule, having a privacy officer, policies and procedures, training, sanctions, and the like, you in this industry, in this time, in this world, you would be safe to assume that it's certainly a best practice to have those in place. I introduced myself as the privacy officer of the advisory board, so clearly we at the advisory board have taken the position that these best practices, looking at the privacy rule, are important because it's very difficult to say that you comply with the use and disclosure provisions of the privacy rule without having a compliance program to back that up. So I'm going to turn it over to Eric Banks now, and he's going to talk about the big whoa, I can't believe this is happening, security rule applicability to business associates. Eric?
Thanks, Rebecca. Well, I think probably the most interesting thing about the security rule changes are that there are actually very few changes. It's really Omnibus rule is really locking in what was in the proposed rule and in HITalk. So the changes are more conforming and procedural than a lot of the changes that Rebecca spoke about related to the privacy rule and the breach notification rules. One specific exception in an area that HHS really detailed an exception is the conduit exception. So when we think of conduits, most of us think of an ISP. That's the example that comes to mind. But the addition of maintain and store beyond transmits really brings some other players, it probably knocks some of these players out of the conduit exception. So if you think about Google Apps as an example, or Dropbox, or Skype, which is a great example because while it seems to be transmitting data, Microsoft has said that Skype actually will store information for a certain amount of time if there's a disconnected connection. So, there's really some interesting discussions yet to be had about the conduit exception and how that's going to affect us. The next change is, and Rebecca touched on this a little bit, it's the relationship between covered entities, BAs, and the BA's BAs. This chain of responsibility, now that subcontractors, or what we were calling subcontractors, are actually BAs, really business associates now need satisfactory assurances from their BAs, and those BAs need it from their subcontractors who are now BAs. So that chain of assurances, or that chain of responsibility, is something that every business associate is going to need to tightly manage. And one other piece to that is that those subcontractor business associates, they must report incidents and breaches, security incidents or breaches, to its business associate, not to the covered entity. So that's another piece of that chain that needs to be tightly managed. HHS overall, I think that they've expected that BAs after HITalk, after 2009, were already meeting their obligations. So there's a general expectation that HHS has that business associates are already meeting these security rule expectations. The unfortunate fact is that prior to HITalk, and even prior to earlier this year when the Omnibus rule was made real, was that HITalk and HIPAA, the security rule itself, was more of a paper tiger for many business associates. HIPAA's or HHS's expectations that business associates are actually ready and are meeting these security rule requirements honestly couldn't be farther from the truth. So when we look at business associate responsibilities regarding the security rule, the 5 things on this presentation slide, they're not necessarily new to the Omnibus rule, but I think it's critical to go over these 5 things just because they were either maybe the definition was modified in the Omnibus rule, or HHS has said that these areas are going to be a focus. So as a business associate, what in my mind is probably the most important function that a business associate needs to perform is risk management. So conducting risk analyses, looking at systems that store PHI, that processes that manage PHI, looking at those critically and determining what the risks are, and out of that creating a set of action items to resolve those risks or to accept those risks in your business. Policies and procedures, we've talked about quite a bit, but sanctions policies, access control, data handling, I think it's important for business associates by September 23rd to have taken a look at their policies and procedures to make sure that they are meeting those security rule requirements. Training is another focus. Obviously, new employees being trained on information security practices and important privacy policies and procedures is critical, but looking at contractors, looking at refresher training for employees who have been there more than a year is an important piece to consider as well. The 4th one, and I think what we hear a lot of discussion about, and it affects everything from cloud providers, cloud storage providers, to backup tapes, to DVDs and things like that, is an encryption analysis. So given that unsecured PHI basically means unencrypted PHI, it's very important, I think, for business associates to know where that PHI lives and ensure that anywhere it does live is encrypted if at all possible. So, the low-hanging fruit of encrypting hard disks on laptops, encrypting backup tapes, any DVDs, USB drives. Those are things that all business associates need to be looking at. The last piece, which is a critical one, is to know your subcontractors. That chain of responsibility that Rebecca and I have spoken about really requires BAs to know their subs. Now, in looking at those subcontractors and the security rule, we found that there are really three groups of business associates out there. So looking at that first group, which is those who are progressive or are deep in healthcare, there's a lot less concern about those from a business associate standpoint. Those business associates probably have security officers and privacy officers, have been adhering to the security and privacy rule and the other requirements, and there's not too much concern there. One interesting area is those that are in the large and industry agnostic. So if looking at the Amazons, the Microsofts, Google with Google Apps, those are folks that have been players as subcontractors with business associates, but really haven't had or haven't known that they needed business associate agreements, adherence to the security rule and the privacy rule. That last group is smaller industry agnostic business associates, and this could be, your favorite shredding company, or somebody who takes hardware donations, or an application that a business associate might use that generates reports. Many of those folks just are not ready for the Omnibus rule. And I think as business associates are looking at their business associates and looking what needs to happen, it's critical to evaluate those subcontractors. Look at providing a risk scoring with appropriate approvals for vendor analysis. The two things that I think many business associates are going to see is that, number one, you may end up saying no to some now business associates who are just not prepared to deal with these regulations. The other side to that, though, is that some smaller subcontractors could be very close. They could have great security focus, great policies and procedures, but you're going to need to help them ensure that they really are hitting those critical areas around the Omnibus rule. So with that, I'm going to hand it over back to Rebecca. I'll come back on the line a little bit later and talk in more detail about some of the specific things that business associates can do in the next 13 days or over the next year or so to make progress on meeting the requirements of the security rule. Rebecca?
Thanks, Eric. I think one of the biggest I call it the game changer for business associates, is that we all know that since the original compliance date for the privacy rule back in 2003 and for the security rule in 2005, the business associates have always had this obligation. They've always had the obligation to implement appropriate safeguards. They've always had the obligation to protect the data. But why now? Why is it that business associates and subcontractors are suddenly sort of throwing their hands up in the air going, what? We have to protect the data? And the reason for that, I would say, comes down to increased liability. So pre-HITech, pre-Omnibus rule, when you're doing your business analysis, you're thinking, okay, I have all these obligations, and quite honestly, business associates, and I'm not speaking to the advisory board here, I'm speaking to my representation of a number of business associates across the country before I joined the advisory board. They sort of said, well, we're signing these contracts, and they were signing them willy-nilly, and they said, well, what's the worst that's going to happen? We have a breach of contract, and we have to pay for any damages from the breach of contract. The risk was just very little. And so, to be quite honest, the government recognized that. The government recognized that there were a lot of folks out there that were business associates that just didn't protect the data. And so business associates have new obligations. And so you're probably thinking, well, what's the difference? They've always had obligations. The difference now is that if they don't comply with the existing obligations and these new obligations, business associates are now directly liable under HIPAA for violations of the security rule. Also directly liable under HIPAA for impermissible use or disclosure of PHI under the privacy rule, or an impermissible disclosure under your BA agreement. And what does that mean? It means the same HIPAA civil and criminal penalties can be applied to business associates. So from a financial standpoint, that's a game changer. That means when you're doing your analysis of what are we going to put into protecting the privacy and security of data, the other side of that scale is potential civil and criminal penalties that in and of themselves have been significantly increased under the Omnibus rule. So moving on to use and disclosure of PHI, Really, I always feel like when I look at the slide, I should think it says not only use and disclosure of PHI, but it's all about the money. And as I came up with pictures for the slide, I thought I could just put dollar signs everywhere, because at the crux of it is that no one likes to think that folks are getting money for protected health information. At its very core, if we all sit here and we get rid of the jobs that we have and we just think, I'm the patient, do I really want people to be able to get my information for money? And I think that's the hardest part for all of us, is to say, well, of course I don't. I get that there's benefits, and that's where you have to go. I get there's benefits for people having access to my PHI, but it can't just be about the money. And I think that's what these three provisions talk about. The first is marketing, and this is always my favorite, because what I always say about marketing is no one should ever be surprised that HHS, or Congress for that matter, has tightened up marketing under HIPAA. It is the only provision under HIPAA that has been tightened every single time that HHS has had the opportunity to tighten it. If you look back at the multiple proposed and final rules back from 2000 to 2003, if you look at HITech, if you look at the proposed rule, if you look at the Omnibus rule, marketing is always tightened. And at the end of the day, what it now comes down to is that, sure, you as a provider, you as a health plan, can describe services that you provide, you can talk about treatment alternatives, but if you get money for making those communications, they're likely to fall under the marketing. And we all know that if you actually use or disclose PHI for marketing, what that ultimately means is you can do it, but only with the individual's authorization allowing you to use and disclose it for that purpose. HHS really understands, though, that refill reminders are an important part of patients' drug compliance. And so they have routinely, throughout the history of the privacy rule, allowed for, well, I shouldn't say that, back in 2000 there was some debate about it, but the refill reminders are permissible. Refill reminders from, let's say, your pharmacy, that you have to renew or refill, rather, the drug that you've already been prescribed, that's okay. And the pharmacy can still get money for that, and it's not marketing, but as long as the only money they're getting for it is the cost of providing that reminder. So big pharma can't come in and pay the big pharmacies of the world tons of money in order to get the pharmacies to go out and send out reminders for drugs if those big bucks that they're giving them are in excess of the cost of the reminders. And again, I say, is anyone really surprised by that? I wasn't. I was just waiting for it to come out, and you shouldn't be surprised. If they ever change it again, I would suspect it would be even tighter. So if you're going to really focus on something and say this is where we don't want to mess up, it's marketing. Next is the sale of PHI. I look at this one and I say, I'm not even sure why we need to include that. But I get it. We want to make it very clear that it's an impermissible use or disclosure of PHI to give someone PHI for money. Obviously subject to certain exceptions, and those exceptions are real business oriented. They're not about selling PHI on the street. They're not about selling PHIs for someone to go do marketing. I put that in there because I say if anyone's really surprised by that, I would be surprised. Again, folks usually are not seeing the government supporting the sale of health information. And then finally at the bottom, this is one of the most interesting ones for hospitals, certainly, fundraising. This is where there was some expansion. Historically, hospitals would have liked to have used a more targeted approach to fundraising. And the reasons for that are because targeted fundraising, targeting certain markets within your patient population, would certainly be more effective. If someone came in and had a successful heart transplant, for example, they'd be more likely to donate, arguably, to the new cardiac wing than someone who was an OB/GYN patient at the hospital. And the other piece of it is hospitals said, we don't want to be sending solicitations for fundraising to folks who have had a bad experience at our hospital. If you had a malpractice suit against the hospital because you had the wrong leg amputated, for example, it would be in very poor taste for the hospital to be soliciting money from that patient, is what the thought process was behind the development departments at hospitals. And HHS got that, and so this was not a huge surprise. They had solicited comments in the preamble, in the proposed rule, asking what types of categories of PHI would be useful in the fundraising arena, and they came out and they said new categories of PHI may be used or disclosed for fundraising purposes, and those are the treating physician, the Department of Service, and then outcome information. And so we're going to give you the ability, hospitals and health systems, to use more types of PHI to do better targeted fundraising and to base it on outcomes. But then we're going to turn around and we're going to, even though we give us, we're going to take us away a little bit here. We're going to strengthen the opt-out rights that individuals have. So for every communication you send soliciting money, you're going to need to provide individuals with an opt-out, saying you have the ability to opt out of these communications. So talking about individual rights, we'll go right into the Omnibus rule certainly expanded some rights. On the access to PHI, individuals have always had a right to access their PHI under the privacy rule. The expansion of the Omnibus rule is that patients now have the ability to receive an electronic copy of their PHI, either themselves or to direct a covered entity to disclose it to a third party. The interesting nugget, if you will, if you look into the preamble to the Omnibus rule, is a discussion about what happens if a patient asks for electronic access to the PHI via email. And you say, but the email's unencrypted. And Eric just talked about encryption. Everything has to be encrypted, and if I don't encrypt, it's unsecured, and if it gets in the wrong hands, there's a breach. And then you're looking at yourself saying, this doesn't make sense. And so the government and HHS says in the language, we hear you that it doesn't make sense that we're telling you to secure PHI on one hand, and we're telling you to provide electronic access on the other. And they say in that little preamble language that basically access wins. They basically say that to the extent that a patient requests email, a PHI in an unencrypted email, that you just have to let them know that that's a risky thing, that they could be subjecting themselves to a breach of PHI, but ultimately at the end of the day, access trumps security. And it's just an interesting dilemma. We have not seen, I've tried to raise this question with HHS sort of informally a couple times, but what happens? Who's liable? I mean, if you notify the patient or the beneficiary and you say, you know what, email's not a great idea from a security standpoint, and they say, yeah, I get it, but send it to me anyway, and there's an issue, there's a breach, who's liable for that? And so the lawyer in me obviously says, wow, that could possibly be the covered entity or the business associate, but that's not been answered yet. I've not seen cases, I've not seen HHS issue guidance on it, so I think we're sort of out there without any guidance on that piece, and hopefully HHS may or may not weigh in on that. Let's get to the other one, restrictions on use and disclosure of PHI. So historically under the privacy rule, individuals had the right to request restrictions in the way in which covered entities use or disclose PHI for treatment, payment, and healthcare operations. But the interesting thing was, all along, covered entities did not have a corresponding obligation to agree to those requests. Now there was some back and forth with the government saying you couldn't just have a policy where you just rejected them all, even though that wasn't in the regulation, didn't say that. But there were some investigations that suggested that. The HITech and the Omnibus rule come back and say, that's right, covered entities, you still don't have the obligation to agree to those requests, except in one very limited situation. When the individual has paid for an item or service out of their pocket in full, so they're not having you go to their insurance company, you, provider, must agree to not disclose the PHI related to that item or service back to their health plan, because arguably there's no reason to. You're not seeking payment because they paid out of pocket in full. Now, it seems very simple and straightforward, and a lot of this was for more of the sensitive types of health information where folks went in and they would say, you know what, I'm getting X, Y, or Z treatment, and I feel like I don't want everyone knowing about that, including my health plan, so I'm going to pay for it. And so there was some good policy behind that. But what we're seeing is that putting that into practice has been very hard to do for providers. Providers are looking and saying, well, what PHI is actually related to the item or service? How broad is that net? And in HHS's view, it might be thinking, well, just this one claim, but that's just not how healthcare works. I mean, all of your healthcare, as we all know, is all very much interrelated. So we're seeing a lot of difficulty in putting that in practice. And then the big question mark, and this is probably the biggest question mark left, the question left unanswered by all of the Omnibus rule, accounting of disclosures. Historically, covered entities have had the obligation to provide an accounting of disclosures of certain types of disclosures for a period of 6 years, and one of the types of disclosures that was specifically excluded from providing an accounting of disclosures to patients was disclosures made for treatment, payment, and healthcare operations. Now, I wish I could see all of you in person, because I'd ask the question that I always ask every time I do a HIPAA presentation is, can I see by a show of hands how many people have ever received, if you're a provider or health plan or a clearinghouse, have you ever received a request for an accounting of disclosures? And to date, and I've spoken to thousands of people. I probably still on one hand the number of organizations that have ever received an accounting of disclosure request. And oftentimes we see it's really out of spite sometimes. And these are all, one-off, comments that people have made to me. But across the industry, folks have said very few individuals take advantage of this right. And because they look at it like, so what? I mean, these people what was the purpose of this disclosure? I don't know. And so you would think that in the Omnibus Rule, in the HITECH Act and the Omnibus Rule, you would have seen some loosening of this. Well, in the HITECH Act, Congress came back and suggested that there should be an accounting of disclosures for TPO, for treatment, payment, and healthcare operations, when they are made through an EHR. Because what Congress envisioned was pushing a button and spitting it out, and everybody would be happy. In the proposed HITECH Act rule, pre-Omnibus, in the proposed accounting rule, HHS took it about 20 steps further. And they came back and they said, you would have to actually provide an accounting of all disclosures of TPO made electronically, not just through an HR, but electronically in any way. They shortened the time period. And then they went further to suggest that you'd also have to provide an access report, setting forth all the individuals who access the PHI, their identity, the date, the time. But they said, but don't worry about the purpose for why they accessed it, because that's too onerous and too burdensome for you. So if you push a button, is what they thought, you'd push a button because you're already required under the security rule to have access controls, audit logs, etc. You could push a button. And it's funny because I've spoken personally to OCR about this, and it's kind of thought of, okay, well, the accounting rule's out there, it's proposed. I think one of the quotes I heard was, it's kind of like we threw a softball over the fence to see how if people would catch it. And I can assure you that the industry pushback across the board has been these access reports don't make any sense. It's not about pushing a button. It's extraordinarily onerous, and it's extremely onerous for very little benefit to the individual. And so I'm glad we have a question mark there. I'm glad it didn't come out in its final form in the Omnibus Rule suggesting that access reports were a good thing. I think what OCR is doing is that they're actually taking their time to address industry concerns in this space because they've seen such a vehement opposition to this expansion of the HITECH Act. So we sit here with this question unanswered, but for the time being, follow the current accounting obligations, which are to account for disclosures, not including TPO. And some will say maybe under HITECH you have to account for TPO in the EHR. So it is yet to be seen, but it's one of the most exciting pieces that we'll see, and again, no timing on when that's going to take place. So skipping ahead to increased enforcement and oversight, I alluded to it a few minutes ago. Remember January 2009, pre-HITECH? Remember 2000, 2001? Remember before HITECH, before HIPAA, 1994? I mean, all of that is gone. And I would say it's gone for good. I don't think anyone in this call should think that we're going to go back through a period of time in 2004, 2005, 7, 8, where there was little enforcement, little oversight. It's just very unlikely for that to be the case. We have post-breach investigations. Like I said, if there's anything 500 or more, HHS, I can assure you, is going to knock on your door if you have a 500-plus person breach. We have investigations of all cases of willful neglect. That's required under the HITECH. We have audits. We have the HHS OCR audits. They completed their first round of, I think it was 115 covered entities, and they currently are evaluating the audit process this year and anticipate, well, they've already said that it will become a permanent fixture, a permanent tool in their arsenal of tools, I think they said it, for investigating privacy and security compliance. So we expect in 2014 that there will be more audits of covered entities and then likely of business associates. We also see state attorney general enforcement, and we saw HHS OCR actually trained the state attorneys general on HIPAA enforcement because under HITECH Act, individuals still don't have the right to sue you for HIPAA violations, but state AGs can come forward and have the right to enforce HIPAA and HITECH against covered entities and business associates on behalf of the residents of their state. And as we've seen in some of the state AG enforcement, they don't necessarily enforce HIPAA and HITECH in the same manner that HHS OCR has historically, and I believe will continue to enforce the law. And then again, the complaint-driven process that we that we've had since 2003 is still alive and well. And so individuals can still complain to HHS, but that's just one of many tools that give insight into HHS OCR when there's lack of compliance. And then in addition to that additional transparency and oversight, the monetary penalties are higher. It's not just sort of, some pocket change anymore. There are significant amounts of money at stake, as we've seen in a number of the settlements that have come out of HHS OCR in the past few years. So with that, I'm going to turn it over to Eric to talk about what do I do? So think about when, not if. Thanks, Eric.
Thank you, Rebecca. I think one takeaway that business associates need to have from this presentation is that mistakes or malicious actors really can break even great technical and administrative safeguards that a business associate can have in place. It's not foolproof. We try to protect via encryption, via technology as much as we can, but there are many processes and procedures that a mistake or malicious actor can cause some issues. So really, it's up to everyone to be prepared for a breach or a security incident. A breach or an incident would likely be a chaotic time, and you wouldn't want to be kind of defining procedures and policies as you go in the midst of a breach or security incident. It's also critical to be prepared for an investigation or an audit. And for a business associate, this audit could come from possibly this year or next year from HHS, or it could come from a covered entity who just wants to ensure, much like you're doing as a business associate with your subcontractors, just ensure that you have appropriate safeguards, policies, and procedures in place. So what should you do now? You have about 13 days. So it's there's 7 things here that you could might want to start taking care of fairly quickly. But in all seriousness, the best thing to do as a business associate is really to create a culture of compliance. And you have to attack that from many different directions. Review, revise, and implement, if you don't have them, critical policies and procedures. Develop, like I mentioned early on, develop and conduct training. And it's not just new hire and yearly recurring training. Training also comprises awareness. So looking at monthly secure behaviors newsletters, teaching employees how to deal with social engineering attacks, how to ensure that you have a secure password, defining what PHI is. Those are some good training topics, I think, throughout the year. Encourage questions and set up processes and means for employees to have those questions answered or to report incidents. Obviously, as Rebecca mentioned, review and revise business associate agreements. And as we talked about a little bit earlier, it's critical to assess your business associates for compliance with the security and privacy rule, that section of the privacy rule that's needed, and really ensure that new vendors are evaluated even while you're catching up on some vendors who may not have been treated as a business associate the first time through. One thing, luckily at the advisory board, we have great senior leadership and board support, but it is important to ensure that senior leadership is aware of the risks that the company is facing and really on board with helping push that culture of compliance through all levels of the organization. Looking at how you can assess your own company for security rule compliance. The key to any assessment, and whether it's for yourself as a business associate, for your vendors, for partners, the key is a good risk assessment. There are some difficult areas there in determining whether you want to perform that risk assessment by vertical or by product or by office or by system that processes PHI. But whatever method you choose, it's critical to have a risk assessment that looks at governance, looks at physical security and access control, vulnerability management, disaster recovery and business continuity. Really those information security keywords and the focal areas that HHS and covered entities are going to be looking at you to meet as a business associate. A good thing about that risk assessment is really once it's developed, you can use a similar assessment for your own internal assessments, for vendors, for partners. Really, you should be looking at those same critical areas no matter what group you're evaluating. And really the last piece here is to, when you're looking at vendors, score them and really approve and reject based on that scoring. You know, the outputs from these risk assessments are going to be action plans for you as a BA, and the output will be either action plans or a yes-no decision in some cases when you're looking at scoring a subcontractor. So looking at focusing on those subcontractors, first, it's important to actually create or hopefully enforce your vendor risk assessment process. Make sure that contractors and vendors aren't slipping through the cracks, and really prepare departments within your company for a possible no answer for a vendor. When you're looking at those vendors, ask them for their risk assessment. You know, create a questionnaire or perform an assessment on those vendors if they don't have that information for you. The third piece on here is one that's often overlooked, and it's critically important. Don't overlook vendor or partner applications themselves. Application security is critical, and it's when we're talking about malicious actors, it's a great way for a malicious actor to get into your organization and pivot to the sensitive data through a gaping vulnerability in an application that's facing the internet. The last point on here, if you're talking to a subcontractor, they handle your PHI and they're not aware of the Omnibus rule, definitely be afraid, and definitely be prepared to either help them if you want to keep them or look for another subcontractor. The things that we have to deal with as a business associate and the responsibilities that we have are too critical to be a practice point for a new company who's trying on the new Omnibus regulations or the security and privacy rule requirements. So with that, I think I'm going to pass it back to Rebecca. She has one more slide to go over, and then we'll have some time for questions. Rebecca?
Thanks, Eric. And just to add to Eric's last point, we at the advisory board, between Eric and me, have this little question, and we say, this is an informal question, we say, does our subcontractor look like a deer in headlights when we say Omnibus rule? And if they look like a deer in headlights, I don't want to say they get an automatic no, but Eric and I like to think they get an automatic no. So the deer in headlights test, if you can use that and take that away from this webinar, I think everyone would feel better about their health information. But moving on, Eric made the point about compliance. It's not about when, it's if, or that's at least how you should be prepared for an investigation. Because what we've seen in the news, what we've seen across the board, is that despite best efforts at compliance, compliance is not foolproof. And we've seen good, great, fabulous organizations across the country have had bad breaches. And they've had mistakes, and you can never be 100% sure that you're not going to be the one that has a breach or that you're investigated. So what I've put together here is a list of the types of questions that I received from HHS OCR and other government agencies on behalf of some of the clients I have in private practice when they were subject to a breach or otherwise an investigation unrelated to a breach or from a complaint. So some of the things I ask for that you should be thinking of if you have an incident: clear documentation of the incident and the facts surrounding the breach or other incident. And the reason for that is they're going to ask you what happened. I mean, that should go without saying, and you want to be able to have it ready to show them that you are making notes and writing down everything that happened and everything that you did. They're going to ask for copies of, they likely will ask for copies of notification letters, breach notification letters, media notices, I referenced that a little while ago, notification to prominent media outlets. And then they're going to ask you for business associate agreements, especially if it's one of your business associates or subcontractors who were involved in the incident. And so these are things that are just sort of low-hanging fruit, that if you don't have these, you're going to start off on the wrong foot with the government. They're also going to ask you, what actions did you take to locate missing data, to mitigate harm, to prevent further loss of data? What did you do to say, wow, we made a mistake, but we moved quickly, efficiently, and effectively to protect the data to the best of our ability? And you want to document that. You want to do everything in your power. Call the police immediately if a laptop was stolen. Even if you don't think the police are going to be able to find it, still call them, still file that missing laptop, the theft report. Try to continue to investigate to protect the data. Security rule risk assessments. Eric has already talked at length about these. You cannot be a covered entity and a business associate in 2013 without being able to hand over a security rule risk assessment to the government should something happen. Right off the bat, if you don't have that kind of a document to hand over, again, on the wrong foot with the government. Have a description of the safeguards in place. So what did you actually have in place? What were the physical, technical, and administrative safeguards that you had in place? Did you encrypt the data? If you've sat through any other HIPAA presentation, you probably have heard Sue McAndrews, an OCR, say, encrypt, encrypt, encrypt. It's like the buzzword of all buzzwords. Is it the end-all, be-all? Probably not. But in the mind of the government at this day and age, they see encryption as sort of this golden ticket, this get-out-of-jail-free card. They look at it as a baseline. And there's a lot of folks that will argue with you, I can tell you right off the bat, that they will point to the security rule and say encryption is an addressable safeguard. Well, that's great. But if you remember, when you're looking at addressable safeguards under the security rule, you also have to document that it's reasonable and appropriate in your organization to not encrypt. And what the government has publicly stated is that it would be extraordinarily hard in 2013. It might be possible. I'm not going to say it's not possible for anybody, but it would be extremely difficult to make a case that encryption is not reasonable and appropriate. And that's a publicly available statement by the government, not documented, but in every webinar in which they speak or any in-person presentation. So if I can leave you with Sue McAndrews' words, it's encrypt, encrypt, encrypt. You're also going to be asked for policies and procedures and then compliance efforts related to those. Don't just have binders on the shelf. Nothing's worse than having a policy that no one knows about and that no one followed, because that's going to rub the government the wrong way as well. So procedures, training, sanctions, show them that you, the organization, did the right thing. You may have had a rogue employee, but at least the organization did the right thing. And we've seen that time and time again, where covered entities and business associates have been let off the hook, so to speak, because they had all of this documentation. They papered up everything they did and said, we did everything we could do, but you, government, know that compliance is not 100%. And the more you can show, the better off you are. And again, incident response and employee sanction processes. When you were faced with those rogue employees, you responded to the incident, you sanctioned them appropriately, and employees knew that you meant business with respect to your policy and the procedures, that you just didn't give a wink and a nod to privacy and security of data, that it really was a culture of compliance within the organization and it was expected of all employees. Thank you very much. I'll turn it back over to you, Lori.
Okay, great. Thank you, Rebecca. We only have a few minutes for questions and answers, but I want to remind everyone that we will follow up with answers in an email. And just as a reminder, you can use the questions on the GoToWebinar panel to submit your questions to Rebecca and Eric. The first question I have for you is, what is the status of the minimum necessary requirement, and how did HITech and Omnibus rule affect that requirement?
Ah, that's a great one. You know, I realized probably this morning that I had left that out, so I'm glad that someone pointed that one out. I have a love-hate relationship with minimum necessary. The minimum necessary standard has been in place since the privacy rules initial compliance date in 2003. And it basically says you can use and disclose PHI, but only use the minimum amount of PHI necessary to accomplish the permitted use or disclosure. So don't use an entire medical record if you only need one claim. And so that everyone sort of, it's kind of a business argument analysis, and it had been all the way up until HITech came along. And arguably, it's a little gray, and it is a little gray because you don't know what the user disclosure is. You have to do a fact-specific analysis of what is minimum necessary. Well, the HITech Act came along, and Congress said in that act that minimum necessary, HHS should issue guidance to set forth what minimum necessary really means. But in the meantime, covered entities should only use or disclose a limited data set, which is basically de-identified data light. That's what I call it. It's basically you're removing 15 identifiers. It's not particularly useful for most things. There are some areas where it's useful, but for a small minority of things. So it said use a limited data set to the extent practicable. And then they followed it up with the phrase, and if it's not practicable, use the minimum necessary. So everyone think about that for a minute. Congress defines the term with the term. So use minimum necessary, use minimum necessary. So I always kind of chuckle and I say, well, that's an interesting, we're back to square one. HHS has not yet issued the minimum necessary guidance, and I hope they do. They can add some some color and some light to this debate. Ultimately, I think it's a very difficult standard in all seriousness to issue guidance on. Like the 4-factor analysis for breaches, I think it's very fact-specific, and I think that covered entities and business associates alike need to be able to make a legitimate, a straight-faced, not a cute, that's a legal term, not a cute argument, but a real straight-faced argument to say, we need this data, this type of PHI, for the following purposes. And you have to be able to stand behind that. And I think that's a legitimate way to define it necessary, but we'll see where HHS OCR comes out. We don't have a time frame for that yet, but hopefully that'll be in the near future.
Great, thank you. We are committed to finishing our webinars on time, so unfortunately we don't have time for any more questions and answers, but as a reminder, we will be sending out a follow-up email that has any questions with answers that have not been addressed live today, as well as a recording of the webinar. So at this time, I want to thank Rebecca and Eric for an informative presentation, and this concludes our webinar today.